Hello, my name is Anna Ardeline, and today I'll be talking about H.R. 10, the Civil Rights of Institutionalized Persons Act, also known as CRIPA. CRIPA was first introduced by Representative Robert Kastenmeier, a Democrat from Wisconsin, to the House Judiciary Committee in 1979, and it was signed into law in 1980. So the first thing that the Civil Rights of Institutionalized Persons Act does is define what an institution is. So the institutions that are specifically outlined are jails and prisons, juvenile correctional facilities, state or locally run mental health facilities, state or locally run developmental disability and mental retardation facilities, state or locally run nursing homes, and juvenile facilities for any state purpose except elementary and secondary education. So an orphanage could be an example. The bulk of the actual legislation in CRIPA can be found in Section 1997A, which involves the initiation of civil actions. According to this section, the Attorney General, acting on behalf of the United States, can sue any state or political subdivision of a state, such as officials or employees of the state, if it is acting in a way that subjects persons residing in or confined to an institution to, quote, egregious or flagrant conditions which deprive such persons of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States, which causes harm. So an important thing to understand about any legislation is what is the actual purpose of the law. So a lot of the significant problems that were targeted by CRIPA were abuse and neglect in nursing homes and juvenile facilities, sexual victimization of women prisoners, inadequate education in facilities that were serving children and adolescents, unmet mental health needs of inmates and pretrial detainees, and the rights of institutionalized persons with disabilities to receive adequate rehabilitation and active treatment. The next section of this legislation that is really specific, but I thought was pretty interesting, was Section 1997E, which involves suits brought by prisoners. For example, if a prisoner raises concerns with the prison conditions, no action is to be brought until all available administrative remedies have been exhausted. Also, courts can dismiss any action brought with respect to prison conditions by a prisoner confined in any jail, prison, or other correctional facility if the court is satisfied that the action is frivolous, malicious, or fails to state a claim that can actually be fixed. So that leaves a lot of discretion up to judges to actually whether or not they believe prisoners and their concerns. Another tenet of this law is no federal civil action may be brought by a prisoner for mental or emotional injury suffered while in custody without a prior showing of physical injury. This is also pretty problematic because, you go through a lot of different issues while in prison that may not just be physical beatings, but the mental wear and tear while you're in confinement goes far beyond any bruise. The next section covers any defendant may waive the right to reply to any action brought by a prisoner confined in any jail, prison, or other correctional facility. Notwithstanding any other law or rule of procedure, such waiver shall not constitute an admission of the allegations contained in the complaint. No relief shall be granted to the plaintiff unless a reply has been filed. So basically, if you're in prison and you want to sue someone on the outside, they have to agree to it, which logically, why would they do that? However, the court can require any defendant to reply to a complaint if it thinks that the prisoner has a reasonable chance of winning something from it. In my opinion, the weakest area of this legislation is its protections for prisoners. All of these groups covered by this law are vulnerable to different abuses, but prisoners definitely are the most vulnerable of all of these groups. Not only are they more susceptible to physical and mental violence, but they're required to jump through far more hoops than any other protected institutionalized group in order for their grievances to be taken seriously. By forcing prisoners' complaints to be filtered through administrative remedies first, yes, the federal government is spared countless cases, but legitimate concerns are much more easily covered up. And since it is the administration who is being scrutinized in these cases, forcing prisoners to face their abusers puts them even more at risk for further abuse. One thing that I would change from this law moving forward would be I would amend it to ensure that persons being detained in ICE facilities are guaranteed protections under this act. CRIPA was passed in 1980, which was before ICE was created, so it would be easy for opponents to make the argument that these camps would not be covered by this law. When analyzing policy, many look at the original intent of the law, and those being held in these camps are not citizens, so they don't have the same rights. However, ICE is a federal agency, so ICE detainment camps would be considered state institutions based on the premises laid out in the beginning of this law. And non-citizens are still guaranteed due process and equal protection of the law as specified in the 14th Amendment. Overall, I think that the Civil Rights of Institutionalized Persons Act does a good job at accomplishing its goals of protecting vulnerable groups in being held in state institutions, but I do feel that it could be expanded to more thoroughly protect certain vulnerable groups.